It is loading.
Loading.
We are live.
Good afternoon. It is January 19th, 2021, 1:30. Welcome to the House Judiciary Committee for today's bill hearings. Members, remember to set yourselves to mute, only unmute when I recognize you for a question. After a witness testifies, you can ask questions by using the raise hand feature on your Zoom window. I'll recognize members in the order they raise their hands. Witnesses, you will unmute yourselves when I recognize you and present your testimony. After you present your testimony and answer any questions from the committee, you'll be asked to exit the Zoom hearing room. Please do not use the chat function when you yourself are not testifying. We're not going to have a running debate in the chat box during the middle of the hearing. Per our guidelines, following bills will work on a 2-minute, 1-minute rule because these are bills that we have heard in the past and passed the House Bills 88 and 231. The following bills will be the 3-minute, 2-minute rule. So 3 minutes for the sponsor, 2 minutes for the witness. House Bills 159, 286, 306, and 372. We'll take a look as we go through each of the bills to determine whether I need to chop up chunks of witnesses or not. I think there's only 1 or 2 bills where we have quite a few people who want to testify. So with that having been said, we'll go now. I think we're going first to House Bill 159. And that's Delegate Grammer. Yeah, House Bill 159. And it's Mr. Lee from the Public Defender's Office. There he is. And then we'll hear from the opposition. Go ahead. We can't hear you. Uh-oh. It appears that Delegate Grammer had to jump off. I want to give him 1 more second and we'll see if he gets back on the line, and then I don't know why I called it the line, the Zoom, and then we'll go from there.
I just admitted him.
Okay, let's try that again. Delegate Grammer?
Can you hear me now?
Yeah, that's better. All right, go ahead.
Sorry for the confusion.
That's all right. This is 3 minutes. Did I say that right? Yeah, 3 minutes for you, 2 minutes for your witness.
Mr. Chair, for the record, Delegate Robin Grammer here to present House Bill 159. House Bill 159 adopts a framework for the legal use of persistent aerial surveillance, including the constitutional check of the warrant requirement. Since the adjournment of our last legislative session, our country has spent much time reflecting on our use of policing authority. Today, I ask myself why the legislature ignores the use of an unpermitted, unregulated, and unconstitutional surveillance system designed specifically for use in foreign military operations. When persistent surveillance systems started surveillance of the city of Baltimore, it did so in a discreet agreement without awareness. After being shut down in Los Angeles and Dayton due to constitutional concerns, the program was brought to Baltimore, authorized by Baltimore City Police, and implemented without input. History has shown us that surveillance authorities are frequently abused. Authorities act in secret, and in these examples, it is nearly impossible to hold a government to account. Persistent surveillance systems is not the only operator in the persistent surveillance space. And as this sector grows, it is expected that companies will become more intrusive to compete. Other states have sent a clear message that they will not allow this unconstitutional technology to be used without a warrant. Will this committee allow the state of Maryland to be the first domino to the implementation of a national persistent surveillance? Thank you for the hearing for House Bill 159, and I'm happy to discuss any questions, and I'd ask for a favorable.
All right, Mr. Levy for 2 minutes, please. Mr. Levy.
Good afternoon, Chairman Clippinger, Vice Chairman Atterbury, and members of the Judiciary Committee. My name is Brian Levy, and as a citizen of Baltimore and an attorney at the Office of the Public Defender, I speak to offer my support to this bill. As I walk out of my Baltimore home each day, I pass under one of over 700 cameras operated by the police department. Driving through the city, my car passes through automated license plate readers, leaving record of my vehicle's location throughout the city that the police can search without any legal showing. Rarely a night passes where I don't hear police helicopters flying low to the ground over my neighborhood, their loud engines audibly disturbing everyone below. They often patrol from the air with their spotlights on, piercing through the darkness and through my home's windows, disturbing my family's sleep. These are just a few aspects of the police's surveillance apparatus. I could go on, as I have only touched the surface, but I hope I have made clear that this bill is not about preventing the enactment of a surveillance state. But that surveillance state already exists, at least in Baltimore City, in a manner that would have been incomprehensible to our founding fathers. With this bill, the legislature has an opportunity to draw a line and impose reasonable limits on the most invasive surveillance tool we have witnessed yet. Some argue that as Baltimore's high crime rate persists despite the current surveillance state, we must allow for the deployment of even further invasive surveillance without any limits imposed by this legislature. I think they have it wrong. The high crime rate in Baltimore does not exist despite the incredible investment in the surveillance of Baltimore's population by the police, but because of it. Because rather than adequately investing in the people of Baltimore, working to reverse the persistent remnants of historical racial discrimination, focusing on rooting out the grotesque concentrations of intergenerational poverty, that is, rather than prioritizing solving the causes of Baltimore's crime problem, we instead continue to prioritize and invest in an ever-expanding police and surveillance apparatus. With homicide rates as high as they have ever been, it should be clear that we cannot surveil, police, or arrest our way out of our city's crime problems. If individual privacy still has any significance to this body, then it must draw the line at the unregulated collection of every person's movements from above using technology developed for military use in war zones. This bill places reasonable limits on new invasive surveillance capabilities and should be enacted with the amendments proposed by the ACLU.
Thank you, Mr. Levy. Are there questions for this panel? I haven't seen any amendments from the ACLU for what it's worth, but I may not have had the opportunity to see them yet. I see Delegate Conaway with a question.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing this bill. Does aerial surveillance include the helicopters?
It would include anything. The bill defines what is defined as aerial surveillance, and that would include anything that takes or captures photos from the sky.
So that could be a helicopter or a drone?
Correct.
Thank you.
Delegate McComas.
Thank you, Mr. Chair. Just a quick question. Are there any similar bills like this that have been enacted in other states that we could possibly look at?
Yeah, I believe I was working with legislative services. I think we might have got this from like Oklahoma or Montana. I'd be happy to find the discourse that we had and forward you that bill. It's very similar. This is drafted from another state.
Thank you.
There are further questions for this panel. I want to ask in the fiscal note, a long time ago, and I actually had a case with it, and it was a DNR case, the Department of Natural Resources case, where somebody was stealing from crab pots out in Chesapeake Bay. And one of the ways that they discovered that they were doing that was through aerial surveillance. And so there is a point in here that actually raises that as an issue in relation to the bill. Not to trying to catch you out, but Delegate Grammer, do you want to address that point? It's obviously not the focus of what you're trying to go for. And I'm not making light of what the issues that Mr. Levy is raising more broadly about what's going on in Baltimore. But I guess there is this issue for DNR. Do you have anything you want to say about that?
Can you help me more clearly understand the question, please?
They sometimes fly planes over parts of the bay where people are stealing oysters or conducting violations of the law with regard to oyster sanctuaries, or the kind of gear that they use, or nighttime deer hunting is in the fiscal note. Nighttime deer hunting and unsafe boat operations. Usually that's boats that are operating at night when they shouldn't be. And sometimes they use aerial surveillance for that.
Sure.
It doesn't go to the core of what your point is, but it is an interesting sort of.
Yeah. So examples of poaching or
Sure.
stealing from other commercial watermen's crab pots. Yeah, I think that's a great point. But this is an executive branch agency, and I would be hard pressed to say that you could give them an exception, or how you would even structure that. I think in that case, they'd probably have to go to a judge and say, look, if you're filming, if you're taking surveillance out in the middle of a heavily wooded area or in the middle of the Chesapeake Bay, you're not going to have as many people. But I think the principle of the matter still stands. And I don't think there'd be many judges that would be disagreeable if you had to make a phone call and get a warrant for that.
The ACLU has, I haven't seen amendments from the ACLU. Do you?
I have
those
not.
are?
I have not, but I can make a couple calls.
All right, well, I'll take a look out for them as well. Are there other questions for the panel? All right, seeing none, that's those in favor. In opposition to the bill is Scott Schellenberger. You're going to have 2 minutes.
Thank you, Mr. Chairman. Good afternoon, all. Honestly, Delegate Grammer couldn't be more inaccurate about the constitutionality. Every one of the cameras that Mr. Levy described, when you drive, when you walk into a grocery store, everywhere you go, are much more intrusive than being thousands of feet up in the air. So the lower cameras are more intrusive and more an invasion of privacy, and yet they do not violate the Fourth Amendment to the Constitution. Now, this body, as Delegate Rosenberg always used to remind me, can give more rights than the Constitution. But if you take a look at my written testimony, the Supreme Court in 2 different cases, Florida versus Riley and California versus Trujillo, has ruled that helicopters and surveillance planes do not violate the Fourth Amendment. And certainly if all the cameras that are in our lives now do not violate it, when you can actually see a person's face when you walk into the Target or the grocery store, how is it a violation that the higher up you go, the more likely it is that there's now a Fourth Amendment violation? So I would say it's not a violation of the Fourth Amendment, and it's actually a very effective tool that I know is not being used right now, but may be necessary and used in the future. Thank you so much.
That was quick. We'll go to Delegate McComas.
You told me to be quick.
Thank you, Mr. Chair. Just briefly, State's Attorney Schellenberger, quick question. How is there seems to be a difference though. If you step out of your house, you got to get out of your house, to get the mail, go to work. Okay. But you don't have to shop in Walmart or Target. And so that's one is voluntary and one is sort of involuntary because you got to take out the garbage and you got to go to work. So how do you reconcile that?
Well, Delegate, thank you. The way I reconcile it is right now, when you step out of your house, a police officer can stand across the street and watch you lawfully every moment of the day. When you walk down to the park, the officer can follow you. It is not against the law. It is not a violation of the Fourth Amendment for that officer to follow you around. If you were in your car in your garage and pulled out and started driving down the road, a police officer could follow you around the entire day, and it wouldn't, as long as they didn't stop you, it would not be a violation of the law. So then you take it the next step. The officer's up on a roof. The next step, the officer's up on a higher apartment complex. The next step, they're in a helicopter, which is exactly what the Supreme Court said was constitutional in Florida v. Riley. Or the next step, and that's the Supreme Court case I reference in my written, where you're up 1,000 feet in a plane. So I understand that you do voluntarily put yourself out there, But even when you're not trying to be out there, the officers have a right to follow you. Now, they don't have a right to stop you, obviously. And that answers Delegate Grammer's one statement, and that is for the Natural Resources Police to be able to go over the water, and if they needed a judge's approval, they would have to have probable cause to believe a crime is being committed. And so if they're trying to scout out what's actually happened, I don't think they would be able to do it under the statute that's written right now.
Okay, Delegate Grammer.
Thank you, Mr. Chair. Hey, Scott, good to see you. A brief question.
Thank you.
This is one of those gray areas in the law that hasn't been opined on specifically because this specific issue hasn't been taken to the Supreme Court. And it is true that in your case, if one of the cases that ruled on a relevant issue was that there are certain public spaces that you can take pictures from, and those specific cases led to an opinion that allowed for the recording or picture taking by law enforcement or anybody else from the public. The closest example of a case that I can find to this issue was the United States versus Jones. And in that case, there was a GPS that was used to kind of create I guess like a showing of personal activity or course of action that created a mosaic of activity. And even though the Supreme Court has spoken about this issue, they have not opined on this issue because it hasn't been taken to the court. But they have said, there are a lot of people, a lot of judges said that mosaic theory would probably stick. And it's the mosaic, it's the creation of connection of images that show a course of action, that you're recording a person or persons that creates the infringement. And I wanted to see if you can comment on that, please.
Sure. So Delegate Grammer, you are correct. The Supreme Court has not specifically addressed this issue with regard to the persistent aerial surveillance. My recollection of the Jones case is they actually attached a GPS to the vehicle.
Yes.
And that they were tracing the person's whereabouts for, my recollection is it was way more than a week. I believe the Supreme Court said that was too intrusive. Now, I believe there's a big difference between flying over a city and not necessarily following anyone individually versus what they did in Jones, which is actually put a GPS on a vehicle. And as you say, that was a good word, mosaic. They kept their a map of where that individual has gone. So one is an invasion of liberty because of the tracking of an individual, whereas the other with aerial surveillance, it's trying to find an entire city so that if a crime happens in a certain area, they would be able to go get those photographs and then focus in. So I think there is a distinction there, but you're correct. The Supreme Court has not ruled on this.
All right. Thank you. I appreciate it.
Sure.
Delegate Bartlett.
Thank you, Mr. Chair. And Delegate Grammer, you actually, the discussion you all just had was in line with my question. I thought that the problem was the persistence. But I do want to go a little bit further, and this is for State's Attorney Schallenberger. Do you think that do you think that probable cause is needed to have the persistent surveillance?
No, I do not believe you need probable
Oh,
cause.
I'm sorry, on an individual.
My recollection in the Jones case was they were not only bothered by the attachment of the GPS, but I think what bothered the Supreme Court more was the length of time. And I'll have to look this up and email you back. But my recollection is one of the justices or two of the justices kind of mentioned that if we limited it to 24 or 48 hours, maybe this wouldn't be as much of a problem. But they did ultimately rule what they had done in Jones was unconstitutional. I think the fact that it's not focused on an individual makes it constitutional. the more you focus on an individual might bring you closer to a constitutional violation. But again, there is nothing to prevent an officer from following me around 24/7 on the street. It's the reasonable expectation of privacy that's protected. Once I go in my house, they can't follow me in there.
May I have a follow-up question, Mr. Chair? So, is it your argument, and I did read your written testimony, and I just wanted to make sure I understood it, everything there.
Yes,
Your
ma'am.
argument, you started with Delegate Rosenberg saying that the states can give more rights. Is your argument is that this gives an enormous amount of rights that weren't decided by the Supreme Court with respect to the following of cats and the other cases that follow?
Yes, if you pass this statute, you will be giving more protections to the people of the state of Maryland than the Supreme Court currently feels are necessary. And that's the conversation I had with Sandy Rosenberg for many, many years. We always had a good time with it.
Okay, thank you. Thank you.
Yes,
I
ma'am.
understand now.
Delegate Cox.
Thank you, Mr. Chairman, and thank you for the bill, Delegate. I had a quick question for you, Mr. State's Attorney Schellenberger.
Yep.
In your comments, I tend to sympathize with the chair in regards to what appears to be a reasonably articulable suspicion. If it's not quite probable cause, maybe it's almost probable cause when you have someone who you believe is committing a crime and you need to do something for that. This bill would require probable cause and a warrant. Seems reasonable, but maybe there's a lesser standard that's also reasonable. I don't know, but you said that, and it's two parts, I guess. You said that an officer could follow someone around 24/7, but my concern is, would you think that a drone could follow someone around 24/7, therefore a police drone, for instance? And then to follow that up would be, where's the line in terms of what the state would view would be the same line of harassment that, you know, the public is subject to?
No, that's an excellent question. And I would call your attention to my written testimony. In Florida versus Riley, the helicopter was 400 feet over the person's house and the curtilage. And Justice O'Connor, in a believe concurring opinion, talked about her concern about getting lower and whether that might be closer to a violation. And so I think that's where your question concerning drones may come into play. And that is, if I were in a drone at a lower altitude following you around, would that somewhere draw the line? And I don't know if we're going to be in a position to say, you know, will the Supreme Court come out with a case that says 100 feet is too low, 400 feet's okay, and we'll be debating for the next 10 years about 300 feet. But in this case, we're talking about a photograph and a surveillance that's far in excess of the California case that I mentioned. So we're going up higher, not down lower. But I do appreciate your question, and it is an issue that will be debated.
Are there further questions?
Thank you.
Mr. Schellenberger? Okay, seeing none, we are then done.
Thank you so much.
Sure. Done with House Bill 159. I do not see Delegate Hartman. Do not see him. That would be a problem. He was supposed to go next, but we will, I see Delegate, don't see Delegate Brooks either. I did see Delegate Jackson. So I think what we'll do is go forward to Delegate Jackson, if that is okay with committee staff. Is that okay? Great. All right, we're going to go to House Bill 306. This is a 3 and a 2. So the sponsor will get 3 minutes. Witnesses will get 2. All the witnesses are testifying in favor. There are 3 of them, so that we will have questions after all 3 are completed. So that's Delegate Jackson, Scott Schellenberger, and Zainab Chaudhry. All right, let's begin with Delegate Jackson.
Good afternoon, everyone. Mr. Chair, Madam Vice Chair, and members of the Judiciary Committee. Thank you for having me today. For the record, my name is Delegate Carl Jackson. I am sponsoring Bill HB 306, which would add making a false statement to a police officer to the list of hate crimes if it is done so based on a person's race, color, religious beliefs, sexual orientation, gender, disability, or national origin. I am introducing this bill in response to an unfortunate situation that occurred this past year in New York City's Central Park that was widely reported on the national news, but more generally, because it's a situation that could occur anywhere. While bird watching in Central Park, a Black gentleman named Christian Cooper came upon a white woman named Amy Cooper, no relation, and her dog, who was walking her dog that was not on a leash. He politely asked her to abide by the rule of the park that dogs must be leashed in that area. Rather than comply with his simple request, she told him that she would, quote, call the cops and tell them that there was an African-American man threatening my life, unquote, which she then proceeded to do, clearly trying to use his race and a false police report to intimidate him. Thankfully, Mr. Cooper was videotaping the encounter at the time, which proved her to not only be falsifying that report, but also pretending to be attacked while on the phone with the police operator. Her intent was clear, though, to escalate the situation and use the fact that he was a Black man to somehow get him in trouble with law enforcement. Thankfully, this situation was not escalated because of Mr. Cooper's calm demeanor and his foresight in taking the video. But it could have ended in tragedy and in imprisonment of an innocent man. This is one of many high-profile instances where law enforcement was called based on someone's race. The prevalence of cell phone cameras is bringing this problem to the public's notice in a way that was unheard of even 5 years ago. Maryland, as a state, must be proactive instead of reactive and discouraging this racially motivated behavior. While this specific example I noted before did not happen in Maryland, it easily could have. With hate crime legislation already law in Maryland, I think that adding making a false statement to a police officer to the category of hate crimes just makes sense. I respectfully request a favorable report and thank you all for the opportunity to come before you.
All right, very quickly before we go to the two witnesses, Delegate Jackson, this is your first bill before the Judiciary Committee, isn't it?
Yes, sir.
Oh, that's very interesting. Okay, we'll get to that in a minute. Delegate, no, not yet. All right, we're going to go to Mr. Schellenberger, then Ms. Chaudhry. Mr. Schellenberger.
So good afternoon again, and I don't mean to shock all of you, but I am in favor of a bill, and that is this one. Delegate Jackson contacted me over the summer after the incident in California, in New York and California. We talked about this, and the reason this is important is because if we just charge the person with false statement, the maximum penalty is 6 months in jail. And that's the only crime that we could have charged with regard to the one in Central Park that Delegate Jackson just described. If we add this hate crime basis to the hate crime statute, or false statement to the hate crime statute, then we could get a maximum penalty of 3 years in jail. And while I know that does not seem a lot, I think it's a big step forward for protecting these rights. And it's not just the incident that the delegate described. Recently, we've all seen on the telephone, the incident on the phone and TV, the incident that happened at a New York City hotel where a young man was accused of stealing a cell phone. And it turns out the woman had in fact left the cell phone in a taxi. And there was no question in that case that race was a large component. So we think this would be an excellent step forward and would take care of a bit of a hole that exists in our law here in the state of Maryland.
All right. Thank you very much. Ms. Chaudhry, go ahead.
Thank you so much, Honorable Delegate Clippinger, members of the House Judiciary Committee. On behalf of CARE, the Council on American Islamic Relations, I thank you for this opportunity to testify in strong support of House Bill 306. We especially like to thank Delegate Jackson for his leadership on this particular issue. Over the course of especially the last year, we've seen a significant uptick, as mentioned before, in the number of reports of racially motivated 911 calls across the nation that have gained national headlines. My organization, CARE, has received complaints from numerous community members who feel like their race or religion has been weaponized by individuals who harbor bias towards them. Some have changed their behavior or the way that they dress or appear in public for fear of being targeted in this way. Needless 911 calls in non-emergency situations are a waste of resources and tax dollars, and also they endanger the lives, especially of communities of color who are directly impacted and disproportionately impacted by them. We strongly support this bill because it sets the tone for accountability, and we believe that it will help discourage such behavior in the future. Therefore, we respectfully urge your favor and vote of it. Thank you so much for your time and consideration.
Okay, now, are there questions for this panel? There are a couple. Delegate Fisher.
Thank you, Mr. Chair. I was trying to be part of that. We all had questions, but I actually do have a question, so I don't know. Hi, Delegate Jackson. It's great to see you, even virtually. So this could be answered by you or your panel, and I, feel, that this is a good piece of legislation. I just wanted some clarification about would the false accusation have to be said directly to the officer or just on the 911 call? I find in such situations that, people will call for law enforcement to come into a situation with a false pretense, with hope to, instate something maybe on a racial lens. But my question is, when you call the 911 officer and you say whatever you say, and then now the officer showed up, didn't actually speak to the person, maybe some use of force occurred due to it, and all the while what was said on the 911 call never occurred. Like, how did those two things meet in this bill or rectified in this bill? That's a weird question, but maybe I'll put it to Mr. Schellenberger for me.
Delegate, may I?
Yes, please.
Okay. So Delegate Fisher, you've actually honed in on something that I had not thought about. It says make or cause to be made a false statement to a law enforcement officer. And so I do believe it would have to be that definition, law enforcement. And as I believe most of you know, in most of our large jurisdictions, the 911 receiver of phone calls is typically a civilian employee. So I think I think you have found a bit of a problem with the scenario that you raised about saying it to 911, but not saying it to the actual officer who arrives. So that could be a bit problematic. I do think this still solves a big problem, and maybe Delegate Jackson and I can figure out some language to fill that hole in.
Thank you.
All right. I'm going to have to try and figure out how many people actually have real questions. So I hope you all have real questions now. I see Delegates Cardin, Williams, and Grammer. Delegate Cardin.
Thank you, Mr. Chairman, and thank you for bringing this bill. I like the bill. I think it's something that could work. Let me just, this is really towards State's Attorney Schellenberger, but Delegate Jackson, if you want to answer. You talked about how you can only charge somebody for a crime that would be a maximum of 6 months. And this would actually increase it to 3 years. If you got 6 months for somebody, Delegate Jackson, would that be enough, you think, in the New York scenario? If somebody went to jail for 6 months for doing this? Or at least got convicted of something that could send them to jail for 6 months?
I think jail time period is sufficient, but whether or not it's 6 months or 3 years, according to our hate laws here in Maryland, if you're convicted of it, it's imprisonment up to 3 years.
Right.
But I guess you would look at the alternative of that. What if the gentleman didn't have video? Could have possibly lost his life. Could have possibly went to jail. No one would have believed him because he's a black male and it's a white woman. So, you
I
know,
lo- Yeah. No, I love the idea of the hate crime. I'm just wondering, like, we're always pushing either to increase penalties or decrease penalties. And the fact is that if we should have a system that works so that the penalties are appropriate, whatever they are. And then, you know, we give judges the ability and the education to do what's right once they have those penalties. But I think that it's, I like the idea of the hate crime, so.
And just so you're clear, if you look at the last page, Delegate Cardin, this sentence could be consecutive to another sentence. So while I understand your point about 3 years concerning the incident in New York in Central Park, you know, may cause you a little bit of pause. You know, we're trying to pass a law that covers things that haven't happened yet, but we're using an example of something that actually happened. And again, this could be 3 years in addition to any other sentence. So I think that's a very good point.
Okay, we do have quite a few questions. It's going to be Delegate Williams, Grammer, Watson, Conaway. Delegate Williams.
So my question is sort of kind of along the same lines as Delegate Fisher. I actually had an incident that actually occurred in my district back in 2019, where there were 2 African-American women who were utilizing the pool in an apartment complex, and a Caucasian gentleman had basically admonished them and called them because they had glass containers with them at the pool area, which was in violation of the leasing codes, the leasing policy of the apartment complex. He reported the incident to the leasing office, who in turn then called the police. And then the police arrived on the scene to deal with regards to the complaint filed against the 2 women at the pool. And I guess that's my concern that I have, is kind of along those same lines. The gentleman did not call the police directly. He contacted the leasing office, who then in turn contacted the police. And how would that play out, that scenario play out under this particular statute?
So as Delegate Fisher got my brain turning, and your question does too, I'll read that sentence again because now I'm reading it a little bit differently. Make or caused to be made a false statement to a law enforcement officer. So I would argue in your case, the intent, and in Delegate Fisher's case with the 911 call, the intent of the person making the call was to make sure that a law enforcement officer knew about this. And so I think there's a very good argument that the word cause to be made would be the intention of that person who called the leasing office, knowing that they wanted police to be there. So now that would be a fact that would be debated in a courtroom, but I think the language is sufficiently there that it would cover both yours and Delegate Fisher's scenarios.
Thank you.
Yes.
Delegate Grammer, then Watson, then Conaway.
I answered my own question. Thank you.
Well, thank you very much. Delegate.
And I thank you.
Delegate Watson.
Thank you, Mr. Chairman. Mr. Schellenberger answered my question with re-clarifying that verbiage, so I'm good.
All right, Delegate, we're on a roll. Delegate Conaway.
Oh, maybe. Thank you, Mr. Schellenberger, for coming in to testify. In reference to the cause to be made, that would not apply to the original concept that Delegate Jackson has put forward, would it?
No, I think it does. I think you would look at the intent of the person making the phone call, and I would have to prove in court that my intent was that police would be involved, and that at the basis of my false statement was that I was motivated by hate, which can be, you know, race, sex, gender, even in the statute, homelessness. So any of those things that describe what hate crimes can be committed against could form the basis for these charges. So I think it covers a lot. I think Delegate Jackson's covered it.
Okay, so, but suppose if it's not what you call a classical hate crime, It's just that you and I get into an argument and I call and make a false claim against you to 911, then what?
Then it would just be a false statement. I would have to prove that my statement was the intent my intent was based on a hate crime basis, which is typically racially motivated. But if you just made a plain old false statement and I couldn't prove you were racially motivated, then that would just be a false statement.
And the penalty for that would be what?
6 months.
6 months. Okay, thank you very much.
Delegate McComas.
Thank you, Mr. Chair. This is just a quick question for State's Attorney Schellenberger, because we know he's so smart. What happens if, let's say, there's a homeless person and they're kind of, don't really have a place to stay, and so they're kind of hanging out where my office is, and I'm kind of concerned about them. So I call up and I say, hey, there's kind of, instead of saying there's this homeless person, I want you to check on and make sure they're okay and that they're aware of services. I say, hey, there's this homeless person that's slinking around the office, and I don't know if they're up to no good or something. Does that, the way I phrase that, does that make me vulnerable if this law is passed?
I wish you hadn't said before your question that I'm really smart.
Hey, you're smarter than me.
No. Delegate, that is really a tough one. I'm not so sure I can answer that. I mean, I think the intent of the statute is that your intent is to make a false statement based on one of those factors. And so the question is, would those factors apply? And that includes homelessness, but it would have to be, my motivation would have to be, I would have to prove it was false based on the fact that you're homeless, I'm making this phone call. I think that's a pretty strong leap. I do remember, I believe the legislature added homelessness within the last few years. Before that, it was what we had traditionally thought about with race, ethnicity, religious beliefs. I think we added homelessness a couple years ago. And I do think that would be a difficult case that you have raised.
Just
Jackson, or
a quick follow-up. Difficult in the sense that I would not be prosecuted, or I could be if we have a really somebody that kind of wants to bust my chops.
I mean, if you said, I'm worried about this person because they're hanging out and being homeless, as long as that's not false, then you wouldn't be prosecuted. If you said, I just saw them steal something when in fact you didn't, then that might be prosecuted.
Well, but we all know that people hear different things, you know, so that's a concern, because it would be he said, she said, they would, you know, if I reported it on 911, you'd have that tape. But I guess I'm a little concerned about it. I mean, I think that what happened in New York is serious, but would that person have some civil remedies to go after the lady that was not truthful, forthright, and just?
You might have civil remedies, but there you have to hire a lawyer. You know, the lawyer's going to want to get paid. The question is, what are your damages? How much money? So, you know, that gets a little bit more complicated.
It's a lower standard, though.
It is a lower standard. You are correct.
Yeah. Okay. Thank you, sir.
Yes.
Thank you, Mr. Chair.
Oh, just when you thought that you wouldn't have any more questions, except Delegate Arakan has a question.
Thank you, Mr. Chair. I'm just trying to understand the second example that Delegate Williams had mentioned about the two women with glass at the pool. I'm a little confused. Okay, so there was two women. They had glass at the pool. They weren't supposed to. The guy who's white calls the leasing office to complain. and then the leasing office calls the police, where in there is there any kind of hate crime? Because did they or did they not have open bottle? I'm confused about. So what's the crime that's happened there, and how can we prosecute that man for a hate crime?
The young women felt as though they were being targeted because they were African American, because there were other individuals that were also at the pool area as well with glass containers, but they were the ones who were being penalized because they had glass containers.
And so the follow-up question would be, was the statement false? So I have to not only prove the motivation, but I also have to prove it was false. And so that's where Delegate Williams' hypothetical or actual case, actual case gets difficult. Was that a false statement or not? It might have been just a pure hate crime by calling on two people who were no different than two other people, but they were a different race. That might be the difference. But under this statute, I have to prove it's motivated by hate and that it's actually false.
Okay, so that clarifies it. I thought you said that they could be charged with a hate crime, but obviously, since it wasn't false, they couldn't be charged with a hate crime here.
Under this new statute, yes.
Okay, thanks.
Well, it is our great tradition to ask a lot of questions of people who come to our committee for the first time, and apparently we did that today. Seeing, I don't think, any further questions. Seriously, Delegate Bartlett, do you have a question? Okay, Delegate Bartlett has a question.
I didn't at first, but because of all the other questions, I now have a question. Welcome, Delegate Jackson. So my question is for whoever can answer. I didn't see the penalty. Where is the penalty stated that corresponds to 10-304-1-4?
So if you look at 10-306, it's on my page 2. That is the sentencing statute that goes along with 304. And what 306 does is that if you violate as a misdemeanor, it's 3 years. If you've done it, if the underlying crime is a felony, then it goes to 10 years. And if it results in death of the victim, then it goes to 20 years. So that's actually listed at the bottom under 306. And so I have to prove the type of injury that it was and what the other crime was. And again, that's where the next page is important, because if the hate crime is the basis for the crime, that sentence can be tacked on to any other sentence. So that's where how that plays out. That's the scheme.
Okay. I think I understand. Thank you.
Okay. I think, wait, is Delegate Eric coming? No, you're not coming back, right? Okay. I think that concludes all the questions on this bill. So we will
Thank you all.
Stop right there. That concludes the testimony for House Bill 306 with Delegate Jackson.
Thank you, everyone.
All right, thank you. We now are going to go back to Delegate Hartman and House Bill 286, if I can find it, which is right here. Delegate Hartman has himself and one other witness. There's one person speaking in opposition. The person in favor is Ross Pizzurro from the Ocean City Police Department. Are they on?
Yes, we are. Thank you.
All right, and then Meredith Wiesel is in opposition. We'll get her on as well. So we're going to go to House Bill 286. Committee at 2:30. I'm going to have to step away for a half hour. The vice chair will take over at that time. That probably will be in the middle of the testimony on this bill. All right, House Bill 286. Go ahead, Delegate Hartman. Welcome back to your home.
Thank you, Mr. Chair, Madam Vice Chair, and members of the committee. It is great to be back. And I will remind you, this is not my first bill, so you don't have to ask me all the questions as you did to the last person.
No, you left us and now you've come back. So now we have to ask you all the questions, but okay, Delegate Hartman.
And I must add, I appreciate you remembering my name. I'm here to request your support of House Bill 286. And the purpose of this bill
is to add first responders, including law enforcement, to the protected class under the current hate crimes legislation. And I'm not doing this as a way to honor or elevate our first responders. I'm doing this because the job that they do is just simply so important. According to Webster's, a hate crime is one of various crimes such as assault or defacement of property when motivated by hostility to a victim as a member of a group. In this case, that group is first responders. It's important to keep in mind that our first responders cover a broad range of age, race, and religion. This bill is aimed to protect all of them from aggression because of the job that they hold. What prompted me to introduce this bill was what I encountered personally during a motor event in Ocean City in the fall, the H2OI motor event. During 2 nights of the event, I rode along with law enforcement, one night the Ocean City Police Department, another night the Worcester County Sheriff's Office. Responding to calls both nights, multiple times, even before officers or anyone engaged, they were met with rocks being thrown at them, bottle rockets, other types of fireworks being shot at them, glass being thrown at them, drinks, all sorts of things. So actually one rock came in and hit the vehicle next to where I was standing. A lot of the times it was the large landscaping rock, 2 or 3 inches, caused a considerable dent to the vehicle. So that's, imagine if that would have hit myself or someone else, it's quite dangerous. And it's a scene that you would never expect to see more or less in your hometown. And if you think about the job that first responders do, they really need to be focused and pay attention to what they're doing so that they can help others. And when they have that type of assault being, released upon them, it makes them harder to do the job that they're there to do, and that's to protect you. So let me leave you with a thought. If you think of many of law enforcement badges, it's in the shape of a shield. And that symbol is to not symbolize authority, but it's a symbol of a shield to protect an individual. Well, that shield, unfortunately, is no longer big enough. And with that, at some point, we have to realize that we're all going to need the assistance of a first responder. So I ask you to keep that in mind. And I ask each of you to vote favorably to support the men and women that protect all of us in our very own communities. And with that, I'll ask Chief Pizzaro if he would present his testimony.
For 2 minutes, please.
Chairman Cookinger, Vice Chair Atterbury, and members of the Judicial Committee, good afternoon. On behalf of the Ocean City Police Department, as its chief, I am humbled and honored to come before you in full support of House Bill 286, hate crimes against law enforcement officers and first responders. Can't say it enough, today the job of a law enforcement officer, whether in Maryland or in the state of Maryland or the United States, is becoming difficult, increasingly difficult, challenging, and most unfortunate, dangerous. While this phenomenon continues, the current protections afforded to law enforcement officers are becoming less effective and seen by many as a non-deterrent. Throughout my career, it's now well into its 4th decade, I have never experienced a period of time when the sentiment towards our revered and noble profession was this negative. The sentiment goes beyond policing philosophies and has increasingly moved directly towards police officers in general, whether on duty, off duty, in uniform, or in plain clothes. Countless violent assaults are occurring in our nation against law enforcement on a daily basis. In Ocean City, we're not immune. Despite being a relative peaceful resort town community, we have experienced firsthand a dramatic rise in assaults on police, over 100% from 2018 to the current. 2018, there were 74 assaults on police. 2019, 113, and 2020, 165. These numbers, they've risen exponentially. Recently, throughout the summer months of Ocean City, in 2020, we witnessed firsthand and fell victim to arguably one of the worst summers in the resort's history, as routine and ordinary interactions with citizens became hostile and at times violent, and that momentum never seemed to waver and just accelerated all summer long. As we entered the fall of 2020, as just remarked by Delegate Hartman, the town of Ocean City experienced the effects of an unwelcome and unsanctioned motor event. Over a period of several days, thousands upon thousands of individuals came into Ocean City. Over this period, there was a prolonged and virtual ongoing clash with the visitors. Although we had planned ahead and had a large law enforcement officer presence to safeguard and protect our community, we became subjects to an unwavering onslaught of non-compliance, menacing and violent behavior. This event culminated in physical confrontations as well as projectiles being propelled and striking law enforcement officers. Although personal injuries and property damages resulted, we continued to perform our duties and provide service necessary to protect our community. This particular bill and its passage is extremely important and will serve as a vital safeguarding measure for first responders as we carry out our respective duties. First, it will serve as a degree of confidence that any individual determined to cause harm to our first responders will face serious consequences.
Chief Pizzurro, we're going to need you to wrap up.
I respectfully request the committee provide House Bill 286 with a favorable report on this bill. Thank you.
All right, thank you very much. Are there questions from the committee for those in favor of the legislation? Seeing none, then thank you very much. That concludes the testimony in favor of the legislation. We have one person to testify against the legislation. And please, I apologize if I'm mispronouncing your last name, but Meredith Wiesel.
Yep, you're good. Thank you. Thank you, Mr. Chairman and Madam Vice Chair and members of the Judiciary Committee. For the record, I'm Meredith Wiesel. I'm a Senior Associate Regional Director for the ADL, the Anti-Defamation League's DC office, and we're here in strong opposition to House Bill 286. For those who don't know, just real quick background on ADL, we're one of the leading anti-hate organizations, and we're also the largest non-governmental trainer of law enforcement, training law enforcement officers on hate crimes, bias, extremism, and terrorism each year. And as an organization, we've also been at the forefront of countering hate-motivated criminal activity for several decades. And because of this, we do not support adding law enforcement and first responders to any state or federal hate crimes laws. There are a couple of points that I want to make. First and foremost, hate crime laws are designed to protect victims who are targeted based on their most precious and personal identity characteristics. For example, race, religion, gender identity, sexual orientation, and such. These are traits that are often described as immutable characteristics. Working in a profession is not a personal characteristic, nor is it immutable. And adding police or any other vocational or employment is only risking the purpose of hate crime laws. It weakens the protections for those who are most vulnerable to their identity-based attacks. The other point is that Maryland law, just like a lot of other states across the country, they already treat assault against a police officer as a very serious crime. And in my written testimony, we footnote the code where it talks about that. It carries a much more severe penalty than an assault against a civilian. Bills like House Bill 286 have a lot of unintended consequences if you're going to make a hate crime, making crimes against law enforcement even more difficult to prove. Crimes against police officers and emergency responders are already taken very seriously under Maryland law, and adding law enforcement and first responders or any other type of employment or profession to Maryland's hate crime statute is unnecessary. It's counterproductive. It also obscures the issue of officer safety at the same time. It's also going to confuse people as to the purpose of hate crimes laws. For this reason, we urge this committee to give an unfavorable report to House Bill 286.
Thank you. I see there's one question, Delegate McComas, if anybody else, and I see Delegate Cardin. So McComas and then Cardin.
Thank you, Madam Chair. Just a real quick question for Ms. Wiesel. We have seen an uptick of police officers being shot in their patrol cars all across the country, Louisiana, New York City. And I guess what I'm concerned about is they wear uniforms. First responders appear with uniforms. A homeless person, you can tell a homeless person because they sort of have a homeless uniform. And I think that, and it doesn't matter whether these officers or the homeless person was white or black or had a religious affiliation or whatever. I mean, people are being shot because of what they're wearing. So I'm wondering why you oppose this so vehemently. Because this is a serious problem.
Sure. No, I'm happy to answer the question. So I think I was pretty clear in my written testimony and then my oral testimony. Hate crime laws were established for people who have immutable characteristics. I'm just going to keep repeating that. It's specific for somebody. It's something you can't change about yourself. If you're going to add something like law enforcement because they're in a uniform, it's the same thing as saying, okay, well, a nurse or a doctor who also may be in a uniform. And I would not say that homeless people have a uniform either. They wear clothes just like everybody else. And I don't think that that's something that is, you're not comparing apples to apples there. Anything that somebody can't change, their race, their gender identity, their gender, their sexual orientation, their religion, those are things that are very specific and why hate crime laws were set up. A police officer who is being assaulted, it's bad. There is no question, but Maryland law already covers that. It's not a hate crime. There is a distinction between a hate crime and a crime, and there is a burden of proof related to that.
Thank you. Delegate Cardin.
Thank you, Madam Chair, and thank you, Meredith, for coming and testifying so well. One thing you said, and I appreciate your perspective. I happen to think it's the right perspective, that penalties are increased if you commit a crime against a law enforcement officer. Isn't it true, though, that penalties are not just increased, they're drastically increased by a significant amount based on Maryland law?
I believe so. I don't have the code in front of me, but we did footnote where it was. So I do believe so. I mean, it's taken very seriously. Maryland is one of those states. I can't pull up the code right in front of me right this second, but Maryland is one of those states that has looked at this over the years because law enforcement, they are out there obviously on the front lines. And I think some of the issues that we've seen, if somebody is prosecuted and it was a law enforcement officer or a first responder who was targeted, then yes, it does, I believe, drastically increase the penalties for that reason, because they were targeted.
And secondly, you had said so well that that these groups, the issue with a hate crime is that it's going after somebody because of a characteristic of theirs that they cannot change, or that is fundamental to who they are. Now, a police officer it may be fundamental to who he is that he's a police officer, but he can change that if he wants. He can take off his uniform, can he?
Correct. Yes, absolutely.
And finally, the group is a very small group of people. In fact, isn't it true that it's only race, color, religious beliefs, sexual orientation, gender, disability, or national origin? That's it. There's no hate crimes for any other groups. Is that my understanding?
No, I'm assuming you mean no other types of professions. I mean, Maryland's hate crime law has expanded over the years to include things like gender identity and sexual orientation. I think you said both of those, but originally, yes, it was race, religion, ethnicity, national origin. They were the original.
Race, color, yes. Religious beliefs, sexual orientation, gender, disability, and national origin. That's
correct.
It.
No profession or professional or vocation. Correct.
Thank you.
Thank you. Delegate Griffith.
Thank you, Madam Vice Chair, and thank you for bringing forth this bill, and thank you, Ms. Weisel, for being here today. I had a question. You said something in your response that, and this is an honest question, talking about the groups who could, be a victim of a hate crime. You talked about characteristics that can't be changed. And you mentioned religion as part of that. And I consider myself a religious person myself, but I do have the ability to change my religion or change to be not religious at all. So I'm just curious how that is, if that's a standard about characteristics we can't change, then I'm just puzzled by that. If you could help clarify that for me, I'd appreciate that.
Sure, but as you stated, you're still a religious person. So it says religious beliefs. So if you're an atheist, if you're agnostic, it's still within your religion as described the way the definitions are. It's still not going towards something that is a profession that you can change at any moment. You can decide what profession you want to be. There is a distinction between somebody who is being targeted based on their religion or based on their race versus somebody who is being targeted based on their profession. There is still a distinction there. And religion, yes, you could convert, to a different religion. Of course you could, but there is the possibility that you could still have a hate crime against you, or somebody target you based on your perceived religion. That's the distinction.
Thank you.
You're welcome.
Okay, I don't see, oh, yes, Delegate Sham. Is your hand up? No, that's my little cursor on there, which is a hand. Sorry. But I said your name right. I was super proud of myself about that. Any other questions? Okay, seeing none, then that concludes the testimony. Delegate Sham. For that bill, if you're coming on, could you mute your hand up? No, that was Delegate Brooks, House Bill 80. But I said your name right. And we have this bill, Delegate Brooks will have 2 minutes. And everyone else will have Delegate Brooks when you're ready. Okay.
Yeah, thanks, Madam Vice Chair and members of the committee. I hear a lot of background music.
Yes, you do. Hold on 1 second. If everybody could please mute themselves. Thank you. Okay, Delegate Brooks.
Thanks, Madam Vice Chair. Thanks for the opportunity to testify on behalf of HB 80 as the police officers' mental health assistance program. Yeah, I'll get right to the point. What does this bill do? This bill will require each law enforcement agency to develop and implement an EAP, that's an employee assistance program, which shall provide police officers with access to low or no-cost confidential mental health services, which includes counseling services, crisis counseling, stress management counseling, mental health evaluations, and peer supportive services. Why is this legislation important? Well, law enforcement personnel respond to and witness some of the most tragic events in our communities on a daily basis. This stress can impact their physical and mental well-being. Nearly 1 in 4 officers has thought of suicide at some point in their life. The suicide rate for police officers is 4 times as high as the rate for firefighters. Many officers died by suicide. Well, more officers died by suicide than in the line of duty than any other profession. And then comparing that to the general population, that this rate is much, much higher. Why should you support this legislation? Well, the Law Enforcement Mental Health and Wellness Act of 2017 was signed into law in January 2018, and it recognized that law enforcement agencies need and deserve support of their ongoing effort to protect the mental health and well-being of their employees. And I, being a Vietnam veteran, I understand PTSD. And when you see things in life that sort of, has a negative impact, oftentimes we react to it differently. And what I tell folks, that there are officers out there who, if they were to go and say, hey, I'm experiencing some challenge or difficulty, there's a likelihood that this could impact their career in a negative sense. So what this bill will do, it will give them the opportunity to go and seek help. They could self-report. It could be reported by a peer, or it could be reported by a family member or a superior. We'll get them the help that they need, because when that officer comes to my door or go to my neighbor's door, I want him to be whole. And that's the whole purpose behind this bill. I've got a panel of some other folks who could elaborate on this to an even greater extent. And here again, the impetus behind this bill is to make sure that not only are we protecting the citizens who the officers are going to interface with, but also protecting the officer as well. Yeah. For that reason, I ask for a favorable report. Now, well, I'll let my panel introduce themselves. Yeah.
They just got knocked out.
Oh, I'm sorry. My panel just got knocked out. Madam Chair,
They're in the waiting room.
they're in the waiting room.
Yes, we just 1 minute. They're
Okay.
about to be let back in. So if everybody,
Okay.
hold on
Okay.
1 second.
And while you're letting them in, I'll say this. We've got written support from Baltimore City Police Department, Riverdale Police Department, the Fraternal Order of Police, Harford County Sheriff's Office, the Maryland Chiefs of Police Association and the Maryland Sheriff's Association, Maryland Psychiatric Society, the Washington Psychiatric Society, the Maryland Catholic Conference, and Dr. Jeffrey Mitchell, who is a critical incident stress management and psychologist and trainee.
Okay, I think Delegate Brooks, we are good to go. 3 of your panelists are here. Chief Morris, Jeffrey Mitchell, and Jessica Murphy. So who would like, and Mr. Junkerman is in now.
Okay, well, let's go with Mr. Okay, oh, Vernon, could you let Vernon Hernan back in? We had him up to go first, if possible.
Okay, 1 second.
He is in now.
Okay,
Okay, good.
so Mr. Vernon,
Heron, yes.
Heron, okay, you can go first, and everyone will have 1 minute. You can
Okay,
go ahead.
thank you. Good afternoon. My name is Vernon Heron. I'm the Director of Officer Safety and Wellness for the Baltimore City Police Department. I'm honored here to testify in favor of House Bill 88. Prior to joining the Baltimore City Police Department, I was a Public Safety Director in Prince George's County. I served in that position for 7 years. Prior to that appointment, I was in the Maryland State Police for 27 years. While in the Maryland State Police, I was unfortunate to be involved in a police officer involved shooting. Although I was not harmed, I suffered emotionally and mentally soon after that incident took place. I was subsequently diagnosed with PTSD. At the time of the shooting, Maryland State Police did not have a mental health professional or an employee assistance program that I could access confidentially. As a result, I suffered in silence for months, turning to alcohol and sleepless nights and severe bouts of depression. Since the adoption of the Baltimore Police Department's confidential employee assistance program, which is available 24 hours a day and 7 days a week, more than 36 police officers have saved their careers by voluntarily enrolling in alcohol treatment programs. Many officers are taking advantage of counseling services, marriage counseling, and EAP services to manage daily stress associated with police work.
Sir,
I realize
wrap it up.
I realize my time is limited, but if I could talk longer, I would tell you about the countless number of police officers whose careers and lives have been saved by our EAP. Thank you.
Thank you very much. I'm just gonna call folks in the order they're listed here. Mr. Mark Junkerman.
Madam Vice Chair, can you hear me, ma'am?
Yes.
Okay, I am Mark Junkerman. I'm with the Harford County Sheriff's Office. I'm an active lieutenant with that agency. I'm starting my 28th year. I'm also a local, state, and national educator for first responders. So I support HB 88. On the surface, there's a lot of good reasons for it, but mainly for the far-reaching ramifications of this. First of all, it makes our law enforcement officers recognize that they're more than just a badge, that they're actually a human being, and that they should ask for help early. That should be the norm, not the exception. Second, it recognizes that we gave these law enforcement officers that badge in the first place. It's not the badge, it's the person wearing it that's so important. The third thing is it actually demands that we in this profession on a daily basis recommit to the mission, take ownership for ourselves, and then also be accountable to and for our peers on a daily basis. It helps our agencies embrace the fact that mental health doesn't happen in a vacuum. It's part of a holistic wellness approach. which is going to create a culture that selects, trains, and sustains the type of protectors our citizens deserve. And finally, it reminds society that investing in our guardians on the front end is going to pay huge dividends on the back end. The bottom line, ma'am, this is about creating the type of law enforcement professional peace officer we want to be and that our citizens need. Thank you very much, ma'am.
Thank you. Chief Morris?
Hi, good afternoon, Madam Vice Chair. It's good to see you, even if just virtually. Members of the committee, I'm Chief Morris, representing the Maryland Chiefs and Sheriffs Association. We are here in support of House Bill 88. We want to extend our sincere gratitude to Delegate Brooks and the other sponsors for the thoughtfulness that's been put into this bill. This bill recognizes and acknowledges that law enforcement officers are humans, that they and the potential detrimental effects of years of cumulative stress, witnessing the worst that humanity has to offer. I'm going to cut my remarks short and only say that this bill, again, recognizes that we have emotions and feelings, that we laugh, we cry, we bleed, we mourn, and that sometimes we display emotions that are contrary to the situation just as a means of coping with the inhumanity. This bill provides the avenue to assist in establishing, defining, and building resiliency and ultimately bettering our service to the communities, and we urge a favorable report. Thank you.
Thank you, Chief Morris. Jeffrey Mitchell? You're on mute, Mr. Mitchell.
Okay, my video is not showing on the former president of the International Critical Incident Trust Foundation. I teach at the University of Maryland. In 2019, 228 officers in the United States committed suicide. That rate is nearly approaching twice the rate of officers killed in the line of duty. There are 18,000 police departments in the United States. Only 5% have a suicide prevention program. And there are a myriad of stress-related conditions that police officers have to endure. One of those worst conditions is post-traumatic stress disorder. Police need the support of mental health services. This bill will go a long way to assisting them. I've taught law enforcement stress management for 48 years, continue to do so. The International Critical Incident Stress Foundation wholeheartedly supports this legislation. And I can tell you that it is the home base for the International Critical Incident Stress Foundation is in Maryland. We've trained support teams in all 50 states and in 35 nations, and the work is recognized by the United Nations.
Thank you.
For these reasons, I ask for a favorable report on House Bill 88.
Thank you. Ms. Murphy?
Thank you very much. Good afternoon, Vice Chair Atterbury and the esteemed members of the House Judiciary Committee. My name is Jessica Murphy, and I am the state conductor for the Fraternal Order of Police, Maryland State Lodge. I'm here to testify in favor of House Bill 88, which calls for voluntary and confidential EAP programs for law enforcement officers in the state. As a 22-year veteran of the Wycomico County Sheriff's Office and a board member of our local first responder peer support program, I have been wishing this day would come. I've been wishing this day would come as our police officers are hurting. They're hurting so badly that nationally 239 police officers took their lives in 2019 compared to 148 that were killed on the line of duty that same year. Passing House Bill 88 will pave the way for our officers to seek mental health treatment when needed and to be reassured that they can receive the help they need both voluntarily and confidentially. When your job requires you to carry a gun, no one wants to admit they're suffering out of fear of losing their job. Therefore, I speak in support for House Bill 88 and ask that you vote favorably for this bill so we can provide voluntary access to mental health services, reduce stigma through confidentiality, and give law enforcement agencies what they need to continue their employee assistance programs. You'll be saving lives by doing so. Thank you very much.
Thank you. And we have one other individual, Brandon Rubin, to testify, and then committee members, please let me know if you have any questions. Oh, I see some hands. Okay. Thank you. Mr. Rubin.
Good afternoon, Madam Vice Chair Atterbury, members of the Judiciary Committee. My name is Brandon Rubin, and as a citizen of Prince George's County and an attorney at the Office of the Public Defender, I speak to offer my support to House Bill 88. As I cited in my submitted materials, there's recent research led by Professor and former police officer John Violante at the University of Buffalo that establishes empirically what has long appeared obvious intuitively, and that is that stressors unique and endemic to police work are associated with a wide variety of acute, negative mental and physical health outcomes for officers. Accordingly, requiring law enforcement agencies to provide officers access to minimal cost mental health services is an eminently rational solution to this well-documented problem. But I want to emphasize that the benefits of offering minimal cost mental health services to officers will, in all probability, in my view, extend beyond simply promoting officer well-being. In all likelihood, offering officers such services will benefit the citizens they encounter in the line of duty, many of whom become the clients of the public defender. We know, unfortunately, that officer use of force or violence is too often not justified when compared against the conduct that stimulated the forceful or violent response.
Thank you. If you could wrap up.
Sure. Mental health services in all probability would better equip officers to avoid unnecessarily using force or enacting violence on the human beings for whom they are professionally responsible. Thank you.
Thank you very much. And there are some questions. We'll start with Delegate McComas and then go to Delegate Williams and then Delegate Watson.
I just want to commend Delegate Brooks. I think this is a very needed bill. My only concern is, and I did not study the text of the bill that carefully, is that is basically the treatment and the discussion is going to remain confidential and will be under the privilege of the psychologist, psychiatrist, patient, so that, in other words, it cannot be subpoenaed or disclosed unless the patient permits it. Is that fair to say? Or would there be a court hearing to determine whether they can get into the records? That's my only concern, because I think you need to have confidentiality in order for this thing to work well.
Yeah, this is confidential. It'd be between the officer and his doctor. I'm a psychiatrist.
Thank you.
Sure.
Okay, Delegate Williams.
I have two questions. First, for the bill sponsor, I saw that Baltimore City had submitted written testimony favorable, but with amendments. And I guess I was just curious as to whether or not the bill sponsor had a comment or anything about the amendments raised in the letter from Baltimore City.
The amendment, I guess it mostly is a favorable amendment. I start off by saying that. And what it's saying, initially what we had it listed as mental health evaluation and someone whose understanding medically of medical terms is better than mine, said a resiliency session. So, and of course I looked up resiliency, and all that means is that that's the capability of a strained body recovering back to its original level of splendor after deformation caused especially by compressive stress. So it's a friendly amendment.
Okay. And then, Madam Vice Chair, I had a second question. I apologize. Mr. Heron, I was wondering if you could elaborate on some of the instances that you saw with some other officers. I know you spoke about your own personal experience, but was wondering if you could also speak about the experience of some of the other officers that you've observed in your extensive years of service in this area.
Yes. So over the past several years, I've observed officers who've been exposed to trauma and without the services of an EAP have turned to alcoholism, have been involved in domestic violence because they had no outlet, no healthy outlet to talk to a mental health counselor. In Baltimore City over the past few years, more than 60 police officers have voluntarily signed themselves in to alcohol rehab. They were not punished, did not lose their jobs. And these are 60 police officers who are back on the street serving the citizens of Baltimore. So EAPs in Baltimore is available 24/7, and every officer has the opportunity to have a confidential session with a trained clinician.
Thank you. Delegate Watson.
Thank you, Madam Chair. Good to see you, Mr. Heron. My question is this. This summer, I had an opportunity to organize with FOP 89, bringing several delegates to a shoot, don't shoot forum, and to get a better understanding of what some of the day-to-day stresses are that police go through. And my question is not for the sponsor, but for Mr. Vernon and the chief that spoke. Why doesn't this go further instead of being something voluntary? I mean, I've never been employed on any job where there wasn't some kind of infrastructure available for me to seek help. What I was concerned about, and I brought up last session, was could there be some kind of annual assessment done for all officers, not voluntary, but that they have to do, where they're able to complete some sort of profile and have some experts to determine whether or not they are mentally fit to continue carrying that sidearm, on their person. And so I just like that opinion. I mean, I wrote some comments down. We're making assumptions they will voluntarily go. No one wants to admit when they are suffering. These are the impediments. And we all know that, our law enforcement officers, very strong people, most type A personalities. And just like some of the rest of us, we hate admitting that when we're weak or when we're suffering or when we're hurting. But if these officers have to go to annual weapons qualification, there is no reason why they can't do some sort of computerized assessment. I floated this idea with FOP 89. They agreed it wouldn't be intrusive. And this is not where you have hours and hours of billable hours of $300 for a psychiatrist to sit down with each and every person. This is a computerized format where if red flags are shown up, then there is some additional effort that is required on that partner. I mean, I have to do this annually myself with National Security Agency, but I don't have a sidearm and don't have the ability to take someone's life. So I'd like one of you respond to that because I think the bill could be strengthened. Thank you, Madam Chair.
Thank you, Delegate Watson. I'll go first. So in Baltimore, we don't have a requirement, but it is voluntary for officers, and a lot of officers have taken advantage of a free mental health assessment from our EAP. We encourage annual physicals and mental health examinations. We've come a long way, and this legislation, the way it's written now, is a big step in law enforcement. When I was a police officer, there was no such thing as stress. If you could not handle the job, you would be washed out. Now it's an opportunity for us to give our officers another tool in their toolkit to get the help that they need on a regular basis and not be penalized and punished. I must say that nationally, the officers don't ask for help, but through education and through our proactiveness in Baltimore City, with a national average for officers using EAPs is less than 4%. In Baltimore recently, we're up to 14%. So our officers are using the EAP, and I think as time goes on, more officers will use it.
Delegate Lopez has a question, but Delegate Watson, I'll just say one of the recommendations from the Police Accountability Work Group is to do exactly what you're talking about. And it came from our very own Delegate Anderson. It was his very strong recommendation that there be the annual mental health assessment, psychological assessment. So I think this committee is going to have to figure out what exactly that looks like.
Madam Vice Chair, if I could, I know the question wasn't addressed to the sponsor, but if you would go to page 2, line 17 under D, and this will tell you those bills is in addition to. So, thank you.
Delegate Lopez has a question.
Sure. Thank you, Madam Chair, and thank you, Delegate Barnes, for this bill. My question is really for anyone in the panel who can answer. A lot of the issues that would bring someone to talk to a counselor are also issues that go on to impact your family. And I can imagine in law enforcement, such a high stress position, that a lot of the stress and the anxiety of that job is taken home to your family. And there's the links between high stress jobs and domestic violence. So I'm wondering if the designs of this EAP program are similar to other EAP programs that I've seen that allow families to participate in them and do some family mediation as well.
I can tell you that our EAP in Baltimore is available not only to our members and is not only police officers, but non-sworn members, but their family members. They get the same access to this EAP as their officers. And it is very important. I think you brought up a very good point that a lot of times when officers go home with stressors, the first ones to know about it are the family members. So we're being very proactive and reaching out to family members as well and making this available to them.
Madam Chair, if you could indulge me one follow-up. Is it possible under the way that this program is being formatted that if a family member notices that their partner or their parent who is in law enforcement is going through some type of crisis, that they can alert EAP? Is that a function of this program?
I could say, yes, it is. You know, a family member could report, self-reported, a peer could report, you know, a supervisor could report. Yes, so all of those reporting mechanisms are available.
Thank you, Delegate.
Sure.
Okay, back again, and it sounds like I don't believe there are any other questions on Delegate Brooks' bill, House Bill 88. Is that correct? Don't see anybody else.
Mr. Chair, if I might say something real quick, and we'll go. This bill passed out of committee unanimously last time. So just wanted to throw that out.
I mean, there's no guarantee of anything these days, you know. But yes, we're aware the bill passed unanimously and that the people in the Senate didn't see fit to move it forward. So we may just try that again. All right. With no further questions, thank you very much, Delegate Brooks, for that reminder. And thank you. That concludes the testimony on House Bill 88.
Thank you, Mr. Chairman.
House Bill 231 with Delegate Polakovich-Carr. There are quite a few people signed up to testify orally. Let me count. 1, 2, 3, 4, 5, 6, 7, 8, 9. So what we'll do, Delegate Polakovich-Carr, I'm going to call on you, and then CP Hoffman, Sasha Bookert, Mark Eckstein, Merrick Moyse, and Jamie Grace Alexander. And then I will go on to Riley Rochong, Darcy Chemnitz, and Gavin Potashnik. Okay? So we will do it in that way. This is a 2-and-1. So the sponsor will get 2 minutes. Everybody else will get 1. We have passed this bill before. This is a rerun. So there we go. Delegate Carr. Jamie Grace Alexander.
All right.
Oh, my.
Thank you, everyone. Sorry, I was getting technical issues there for a moment. Yeah, so for the record, I'm Delegate Julie Polakovich-Carr here to present House Bill 231. This legislation would prohibit use of the panic defense in Maryland courts. And basically, the panic defense is a legal strategy that asks for justification or mitigation of a defendant's alleged violent actions because of characteristics of the victim. And it's most frequently been used against people who are LGBTQ+. As noted in Attorney General Brian Frosch's testimony in support of this bill, quote, the discovery or perception of a person's racial, sexual, or gender identity can never be adequate provocation for murder or assault, end quote. As noted by the chair, yes, this bill did pass the committee last year. It in fact passed unanimously, and it passed the House with only 1 dissenting vote before running out of time in the Senate. I certainly hope we can get this across the finish line this year and make Maryland the 12th to ban the use of the panic defense. I will note that we do have written testimony from a number of entities that will not be testifying orally today, including from Attorney General Frosch, from the state's attorney for Baltimore City, Marilyn Mosby, from the Latino Caucus, from NARAL Pro-Choice, and the Maryland Psychological Association. And lastly, let me just note that I've become aware recently that the Maryland States Attorneys Association is going to be proposing a technical amendment to the bill, and I have reviewed that amendment and am supportive of it. And with that, thank you.
All right, CP Hoffman.
Hello, thank you, Honorable Chair, Vice Chair, and members of the committee. I'm CP Hoffman, the Legal Director at Free State Justice, which is Maryland's LGBTQ advocacy organization. Despite significant advances in recent years, LGBTQ Marylanders continue to be subjected to intense discrimination and violence at rates significantly higher than other communities in the state and across the nation. This violence also hits transgender individuals and queer people of color especially harshly. Unfortunately, Maryland law currently allows criminal defendants to rely on on the panic defense to mitigate their offenses, allowing them to get away with murder and assault of LGBTQ plus Marylanders. As I explained in my written testimony, which I encourage you all to look at, the panic defense can take a number of forms, but in most cases, it's premised on the idea that the victim's sexual orientation or gender identity somehow provokes the defendant, or that they were so psychologically upset by someone's gender identity or sexual orientation that they lose self-control and act violently to the victim. While it's not a total defense, we found multiple cases in Maryland where defendants have successfully had first-degree murder charges reduced to either second-degree murder or into voluntary manslaughter. Maryland law should not condone this violence against the LGBTQ plus community. And just as this legislature acted in 1997 to eliminate similar defenses in spousal murder cases, I ask the committee today to support HB 231. Thank you.
Thank you very much. Sasha Bookert, and I may have butchered your last name. I apologize for that.
No, that was actually great. Thank you. Good afternoon, Chairman Clippinger and members of the committee. My name is Sasha Bookert, and I'm a senior attorney at Lambda Legal, and I'm testifying in support of the bill. LGBTQ people and transgender women of color in particular move through the world under the constant threat of impending violence. In the words of one transgender woman of color in a New York Times article recently stated, "It's always in the forefront of our minds when we're leaving home, going to work, going to school." The fear is well substantiated. In 2020, there were 44 reported murders of transgender or gender nonconforming people across the country, the vast majority of whom were transgender women of color, which is likely a significant undercount. Similar legislation to HB 231 has been passed in multiple states, as has already been mentioned, and similar legislation is pending in many states as well. Allowing this defense dehumanizes LGBTQ people and sends a message to other defendants or would-be assailants and to the public that they can always rely upon this to mitigate any punishment. The panic defense uses the bias of jurors and the judge to their advantage, and it perpetuates anti-LGBT stigma and suggests, as the ABA points out, it runs contrary to our constitutional values as a society, and it should be eliminated before it can be used again. We urge the committee to advance this important legislation. Thank you.
Thank you. All right, Mark Eckstein.
Good afternoon, Chair Clippinger, Vice Chair Atterbury, and members of this Judiciary Committee. My name is Mark Eckstein, and as a parent, I strongly support this bill, HB 231. I'm co-chair of advocacy for Metro DC PFLAG and also work with many LGBTQ students throughout Maryland. When I interact with these students, panic bias defense is one of the most important issues for them. And not only is this specific defense ban needed, but this legislation also sends a very powerful message, especially to our youth, that violence cannot be a response just because you're uncomfortable with someone. So I urge a favorable report on House Bill 231. Thank you and stay safe.
All right, thank you very much. We'll go to Merrick Moises.
Good afternoon, everyone. Greetings, distinguished chair and members of this committee. My name is Merrick Moses Moise, and I'm a victim advocate with the Office of the State's Attorney for Baltimore City. I've been an advocate within the LGBTQ community for 19 years and a community peace activist since 1990. And in my travels, I've met many queer and trans people who are afraid of the criminal justice system, believing that they will not be treated fairly or justly. They have witnessed their queer and trans siblings in community not receiving the justice that they desperately seek. Case in point, Mia Henderson was a young trans woman killed in Baltimore City in July 2014. During the trial of her alleged killer, defense counsel weaponized her gender identity. The public defender asked her own witness if Mia, quote unquote, looked like a boy or a girl at the time she was last seen. And during closing arguments, the public defender told the jury that Mia hadn't even had sex reassignment surgery yet. Mia's family and friends were shocked and disgusted by the public defender's crass attempt to reduce Mia to her body parts. And yes, this happened in Baltimore City with a Baltimore City public defender. My hope today is that we begin seeing LGBTQ people with dignity and respect and not reducing people to their body parts or surgeries. We are a very vulnerable community that continues to fight for dignity daily, and the American Psychiatric Association has debunked the gay panic defense in its manuals. It is high time that the state of Maryland ban LGBTQ defense. Thank you.
Thank you very much.
Good seeing you.
Very good seeing you. There may be further questions.
Okay.
Amy Grace Alexander.
Hi, everyone. Professionally, I'm the Legislative Outreach Coordinator here at the ACLU of Maryland, but today I'm here representing the interests of Baltimore's Black trans community, whose oppression is upheld by the trans panic defense. Though the bill has been revised to include several other identity protections, I'm here to specifically address the origins and consequences of this defense for gay and trans community. First, it's important to state that disclosure should always be left to the discretion of the LGBT person in order to reduce already disproportionate violence. This issue is deep-reaching, though its highest consequence. Professionally, I'm the legislative for people like me, Black trans women who stand the most to lose from outing and other phobic violence. 4 years ago, the murderer of Mia Henderson, the 26-year-old victim of a brutal stabbing, was acquitted using this defense. Her death in 2014 was felt deeply in our community, as was the October 1996 murder of Anthony Gabriel Barnes by Charles Garney in Prince George's County, Maryland. The panic defense is at the extreme end of transphobia and homophobia, and because it's only used long after violence has taken place, its only purpose is to legitimize that violence. The real panic is the fear of being discovered in your natural state, that the peace of your passing be disturbed, the unrest in knowing that your offender would suffer less because of who you are. Thank you.
All right, thank you. Thank you very much. We'll take some questions here and then we'll go into the next group. Are there questions for this panel? Let me go to Delegate Polakovich-Cart. Do you, I don't have the technical amendment from the state's attorneys. Can you, you are not speaking on behalf of the state's attorneys. No one is here. I'm just asking if it's a simple one, can you describe what that would do?
Certainly. It has to do with the section of the bill that does with mitigation of assault. And they pointed out that basically the language that says that it does not constitute legally adequate provocation to mitigate an assault from first degree or second degree would actually be better and more supportive of the intentions of the bill to change that all to it's not a defense to first degree assault to second degree assault. And I have submitted something to the amendments office in this regard and happy to pass it along to the committee once we get that language back.
Okay. All right. Thank you very much. If you'd pass that along, I think we'd go to Claire Rossmark on this bill. Okay. Are there further questions for this group of witnesses, this panel? Are you waving, Delegate McComas? All right, Delegate McComas.
Thank you, Mr. Chair. I have some questions and they're not necessarily on point, but I assume everybody's familiar with some of the Dirty Harry movies, you know, where, you know, how many rounds did I shoot? You know, I think a lot of times I assume that none of the folks that are being harmed, the transgender folks, are get the ability for the right to carry. Is that a pretty good assumption? I mean, does the community try to get the right to carry to protect themselves since they are a vulnerable class?
If I could answer that, anecdotally, I have heard of specifically Black trans women fearing for their lives trying to get permits. So that's happening right now.
Well, but do they receive the ability to the right to carry, to protect?
I've only heard about people wanting to carry. I haven't heard them being prohibited to carry, but it is an issue in the transgender community.
The other question I have is there any movement within this community to learn self-defense? You know, either, you know, some of those, I guess there's Chinese and Japanese different ways to that basically you use the, what do I want to say, the force of the other person to protect yourself. It's kind of, I guess, like jujitsu or something. I just wondered if that would help the community, because somebody be less likely to pick on someone if they just didn't know whether they had the ability to protect themselves, you know, through weapon or physically. You know, I'm not talking about the bill, because obviously the bill is needed, but just the idea that this would be an added protection, because I always tell domestic violence clients, paper doesn't help you. You know, if somebody's going to go after you, you need to either disappear or protect yourself somehow. So I just kind of was curious to know how much of an effort that the community is making to make themselves less vulnerable.
I guess my question, though, however, will be, I'm going to bring us back to the bill. I think the issue here is that of the gay panic defense, and not whether transgender people or LBGT people should be going out and getting firearms in order to protect themselves. So to that end, if you have a question about the gay panic defense, we can talk about that. But if we're going to ask questions about that, but if we're going afield here, I'm going to try and bring us back. Do you have a question on the panic defense?
I just wanted to contribute momentarily on that idea.
Sure.
As someone who is testifying in favor of the bill, it sounds very troubling that essentially that kind of thought process would lead us into a position where, sure, we can tell trans people to buy guns, but then if they happen to be unsuccessful in defending themselves, then the law would not offer them any recourse if they tried to use that defense, or if their perpetrators try to use that defense in the court of law. The problem isn't with the fact that they could defend themselves. The problem was with the fact that, like, this defense can be used at all. Like, I don't think that bringing up the fact that they could buy guns addresses the underlying issue that the bill is trying to address.
Right.
As many women, for instance, go through self-defense classes to protect themselves. Many members of the LGBTQ community and the trans community specifically also take self-defense training. They carry you know, various things for self-defense with them, depending on the circumstances. That is unrelated to whether people should be able to murder us.
All right. So let's do this. Are there further questions for this panel on this bill? Delegate Bartlett.
Thank you, Mr. Chair. So my question, I'm not sure, maybe to the bill sponsor, Delegate Palakovich-Carr, and I'm being a little lazy. I could have looked it up, but are there cases that in which, okay, I see Darcy is saying yes. Okay, so my question is, what was the discussion by the judiciary with respect to was the result that the defense was brought up and the judiciary knocked it down, or was the result that the defense was brought up and the judiciary accepted it and the court accepted it?
Yeah, this is a great question. And I think maybe one of the witnesses who might be signed up in the next panel probably can speak to this as well, but I'd be happy to defer to any of the folks who are on here. But yes, there have been cases in Maryland. I don't think they've been successful for the most part in terms of the use.
Okay, great. I was hoping that was the result, but I just wanted to make sure that it hadn't been somehow a part of dicta in a case where they were leaning towards accepting this as a defense. So thank you very much, Delegate.
If I may make a quick point, in my written testimony, I talked through 5 cases in which the panic defense was used in Maryland that we were able to identify. Now, as I note in that testimony, there's possibly far more than that have occurred, but that we just don't have a record of. And I explained some of the difficulty in pulling out that record. But we've identified at least 5 cases, and in 2 or 3 of them, it was successfully used by defendants to get their charge is mitigated from first-degree murder to either second-degree murder or to voluntary manslaughter. So these types of defenses have been allowed by judges, although the most recent of those cases was about 10 years ago. So we haven't seen it used in the immediate past in Maryland, but there has been a history of this defense being used in Maryland.
And if I could just add that Mia Henderson's case really illustrates how the defense skillfully tried to weaponize her gender identity, and it caused her family and friends great distress, especially when she remarked on sex reassignment surgery, which had nothing to do with the case.
Right, thank you.
Are there further questions for this first panel? There's another panel after this one. All right, seeing none, we'll go to the second group of people who are signed up to testify, and that includes Riley Rochong, who already spoke up a little bit, but okay. And then Darcy Chemnitz, and is Mr. Potashnik on the line? Don't see Gavin Potashnik, but let's go ahead with
Here.
Rochong. Oh, he is there. Oh, I see you. Okay, that's fine. Riley Rochong, we'll start with you.
Thank you, Chairman. Yeah, my name is Riley and I use she, her pronouns. Currently, I serve as the co-chair for the Outlaw Student LGBT organization at the University of Maryland School of Law, as well as serve on the board of directors for Free State Justice. Naturally, this issue is important to me. Last year in criminal law and while clerking for the Organized Crime Division of the Maryland Attorney General's office, I learned about the type of homicide that the trans panic defense would be used against. To try and mitigate a charge of murder to voluntary manslaughter, defendants would argue that their killing was justified because they were acting in a heat of passion where any other reasonable person would have also killed the victim for acting deceptive. To not mince words, what they're literally arguing and what we allow them to argue is that their murder was justified because any other reasonable person in society would have also killed the victim because they are trans. They argue that trans victims' lives, as well as my life, are worth less than others just by virtue of who we are. This is why passing House Bill 231 is necessary. My life is worth just as much as everyone else's here, as everyone else in this call. And it's an injustice that the law does not reflect that. Please give a favorable report on House Bill 231. You did so last session, and I'm asking that you do so again. Thank you.
Darcy Chemnitz.
Hi, my name is Darcy Chemnitz, and I'm the Executive Director of the National LGBT Bar Association. We were formed over 30 years, sorry, starting my timer, formed over 30 years ago by a small group of family law practitioners at the very height of the HIV/AIDS crisis. And we are leading an effort to ban the panic defenses across the country, and I've submitted written testimony. You know, they teach us in law school that criminal law does two things. It provides a set of rules and actual punishments for people who break a very well understood boundary, but it also gives a sense of where that boundary stands. And so this proposed bill sends a message about what is acceptable and what is not acceptable. And may I just say, as it relates to victims on this, I'd like to bring you back to the year 2000, in which Monsignor Wells was stabbed in his own, in Mother Seton Parish. And weeks later, that defendant said he was going to sexually assault me. Weeks after the stabbing, this individual came up with that defense. So those are the kinds of cases where this is used, Delegate Bartlett, and I urge your passing. Thank you.
Thank you very much. All right, and now Gavin Potashnik.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. It's good to see everyone, even though it's on Zoom. Really, I'm here to talk about the amendment component of this. The MSAA is in support of this bill. We're favorable with amendments. The whole point of the amendment is really to strengthen the intent of the bill. When you're dealing with mitigation, you're dealing with degree. And for degree of murder is really wrapped up in the why it is that you committed the murder versus the murder itself. At the end of the day, you still have a dead body. When it comes to assault, the degree of assault is really wrapped up in the extent of the injury. So if somebody's arm is chopped off, then that is obviously a first-degree assault versus somebody's slapped, even though somebody says, I'm going to kill you, that is not a first-degree assault. So for us, if you want to help us out to make sure that this will work in court, really the best way to implement this is to bar the defense completely as it respects to assault, rather than make it a mitigation factor in the assault world. And so we're favorable with that amendment. Thank you so much.
All right. I apologize to Delegate Polakovich-Carr. I missed that Mr. Potashnik was on the list, and I would have asked him about his amendment, but now he's talked about it and you've talked about it, so we've all talked about it. Great. Are there questions for that second panel? Seeing none. Thank you all very, very much. That concludes the testimony for House Bill 231. And we're going to move on to our last bill of the day. That is House Bill 372 with Delegate Moon. And there are quite a few people signed up to testify for and one against the legislation. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12. So I think what I'm going to do is there are 12 and then Delegate Moon as well. So we're going to do Delegate Moon and 6. No, this is a 3 and 2. We'll do Delegate Moon and 4 of the witnesses, then another 4, then another 4. So the first 4 will be Rajani Goodlevaletti, and then Michael Hilliard, Moon and 6. If you are joining us, make sure you mute yourself.
Thank you so much.
So that's Rajani, Michael Hilliard, Dave Fell, and Christiane Marguerite will be the first 4 of the witnesses to testify, and then I'll go from there. Then it'll be Ron Phillips, Stanford Frazier, Alex Wilson, and Joseph Adams. Then it will be Harriet Smith, Samantha Kerr, Nancy Rosen-Cohen, and Tiffany Scott. So let's start now with Delegate Moon and that first group. Delegate Moon.
Thank you, Mr. Chair. Colleagues, you may recall this bill from last year. It was brought to us by the Baltimore Harm Reduction Coalition and a coalition of public health and harm reduction advocates. And basically, it's a modernization of Maryland's war on drug laws and approach. So just for background, we have jail terms that apply to possession of drugs, and then we have jail terms that may apply to possession of paraphernalia related to drugs. Over time, we got rid of penalties related to some marijuana paraphernalia, and over time we've been chipping away at it. And there's 2 categories of paraphernalia that are subject to up to 4 years in prison in Maryland. Some relate to drug dealers and drug producers, and others relate to drug users. And so this bill attempts to decriminalize the paraphernalia with respect to drug users. It leaves some penalties in place for dealers and producers. And it continues an approach that we've been trying to get to look at these as public health issues and not issues that are appropriately dealt with in the criminal justice system. Key reason for this that we raised last year that I'm happy to talk about more if there are questions is that if you make it a crime to possess a syringe, whether clean, dirty, or whatever, for example, you hamper the public education around that, you stigmatize them, and you have people dumping them everywhere, not disclosing them to officers when they're being apprehended, etc. All of this just leads to public health problems. Moreover, we've now forgot to take down the penalties on drug paraphernalia. So we're in a scenario where the pipe you smoke your crack in can lead you to far more incarceration than the crack itself. And so again, this is inappropriate. We got to move to a treatment and health response and get away from this war on drugs approach. We got a number of people that are happy to provide more details from the ground on that. So thank you, colleagues.
Oh, okay. We're going to go to 2 minutes for testimony now. And I'm going to just make sure some people are in. Some people are not. We will try with Rajani Goodlavaletti. And if I probably screwed that name up too. There she is. Great. Let's go. 2 minutes.
Hello, can you hear me?
Yes.
Excellent. Okay, thank you. Hello, everybody, honorable committee. I am Rajani Goodlavaletti. I am Director of Mobilization with Baltimore Harm Reduction Coalition. And I am here actually at the BHRC staff. I'm with BHRC staff, all wearing masks at our office. And so we are here to provide our testimony in strong support of this bill. We all seek an end, all of us here seek an end to overdose and an end to violent policing. This bill will work to address both of those issues and more. As the number of syringe service programs have risen, we are now up to 16 syringe service programs in the state. It is a natural next step to decriminalize paraphernalia that people will be carrying from access to those life-saving supplies. The written testimony, there's been a series of written testimony provided that unequivocally illustrates the public health benefits of harm reduction practices, such as those outlined in this bill. And so what I want to focus on in representing BHRC right now is that harm reduction saves lives and requires community trust. And what we know, and if we didn't know this before, we sure know this now, fear and distrust of police are why we need this bill. People do not trust the police. The police are confused about current legislation around paraphernalia. This doesn't add any help when people are having to consider, will a police officer stop me or harass me? This bill will help protect our people. Fear and distrust of police are why we need this bill. People who use drugs and harm reduction workers cannot trust police to keep us safe under really any circumstances, let alone understand current laws around paraphernalia. This bill will increase safety and work towards our goals, our collective goals of ending overdose and ending violent policing. I'm happy to answer any questions that you all have. Thank you.
Let me ask a question very quickly here, just so that staff can maybe understand why we don't have as many of you in the waiting room. There are several other people set to testify from the Harm Reduction Coalition in Baltimore, and I'm assuming that they are there with you.
They absolutely are in the wings. We are we are practicing social distancing. So I took my mask off. We have a fan going, and David Fell will come in through, and Harriet and Ron as well. So they are ready and waiting.
All right, that clarifies that mystery. We're going with further witnesses, including right now with Michael Hilliard. But now I understand how that's working.
Yeah, we're trying to help you. We're here to help you. Thank you.
See something different all the time. All right, let's go with Mr. Hilliard, please.
Thank you for hearing this bill. I'm testifying today as a resident of Towson and a retired major with the Baltimore Police Department. I support HB 372. It's time for our state to take the next step and decriminalize paraphernalia possession. There is no public safety rationale to keep arresting people on this charge. In all my years of policing, I've never seen a serious threat to public safety be resolved by a paraphernalia arrest. Decriminalizing syringe possession would also help patrol officers who are at risk of accidental needle stick every time police make an arrest. We search the person before detaining them. As we pat them down, we ask the suspect if there is anything in their pockets or bags that would hurt us. Suspects will often lie if they're in possession of a syringe, hoping to avoid a paraphernalia charge. Researchers have found that 1 in 3 police officers are stuck with a needle while on the job. This legislation would also reduce the chance the needle in their pocket carries an infectious virus. When people know they can be arrested for syringe possession, they are more likely to share syringes to minimize their chance of arrest. This bill would also reduce syringe littering. When we punish people for syringe possession, they do not risk carrying a used syringe with them to dispose of it safely. Instead, they leave it wherever they use it, in a park, in an alley, or in a public restroom. We shouldn't have to worry about our children playing barefoot in the park or our custodians being stuck by needles at work. Thank you for this opportunity to speak to you today.
All right, thank you very much. Now I'm going to alter things a little bit as we've now figured out what the Baltimore Harm Reduction Coalition is doing. Is Dave Fell there? That's you, Dave Fell. All right, well, testify. Go right ahead for 2 minutes.
Great, you can hear me?
Yes.
Excellent. My name is Dave Fell. I was planning on barreling through all of this information in 1 minute, so I'm gonna slow down and speak a little slower here. I do street outreach and SSP service provision for Baltimore Harm Reduction Coalition. We often talk about a hierarchy of risk when it comes to introducing drugs into the human body. And at the top of that list is injection. It is by far the riskiest with the highest chance for spread of bloodborne infection. When we do our outreach, we also provide supplies for people who snort drugs and supplies for people who smoke drugs. And because of this, we have actually seen some of our participants switch from injecting their drug of choice to either smoking or snorting. And this is good for public and personal health, period. So with that, we are asking for clarity in this drug paraphernalia law so that we as harm reductionists know what we can legally provide, and so that our program participants know unequivocally what they can legally have on their person. So we are asking for clarity in this law and the decriminalization of drug paraphernalia. Thank you for hearing this bill, and I hope you vote yes. Thank you so much.
Thank you very much. Is Christiane Marguerite there? Probably not there, but no, we don't have her in the Zoom. I'm going to keep going. I don't know that we have Ron Phillips either. Is Ron Phillips? We do have Ron.
We do. We'll get
All
him
right.
from the wings. Here he is.
That's fine. We'll take Ron Phillips and then we'll take questions for this first group. Mr. Phillips.
Hello, how you doing?
Great.
First of all, I am an outreach specialist for Be More Power, and I volunteer for the Baltimore Harm Reduction Coalition, as well as a syringe service provider. A special hello to Delegate Kurt Anderson. He successfully represented me in a drug charge in '92. So it's great to see him, his name and everything. And yeah, what I want to testify is that in my outreach, I find that people are still giving me information that they are going to jail for tools that they use to basically live pain-free and, for that matter, survive. And I'd say to that we should not blame the citizen for self-medication. It's a problem that could be eradicated in the changing of the law. And I support that highly. And that concludes my testimony.
All right. That is just fine. Thank you very much. All right, we'll take questions for this panel and then we will move on from here. So if there are questions for this panel, please let me see. I don't see anybody waving their hands or raising their hands on the Zoom. So with that, that'll be the questions for this first panel. Let's go to this. So what I'm going to call the second panel, Stanford Frazier, Alex Wilson, Dr. Joseph Adams, and then Harriet Smith from Baltimore Harm Reduction. And I'm assuming, yes, and they're nodding their heads saying that they are there as well. So Mr. Frazier to begin, please.
Good afternoon. I'd like to thank the chair and the vice chair for having me on this panel today. I'm here with the Public Defender's Office. My name is Stanford Frazier and I'm a public defender in Prince George's County, and we are in support of this bill. We want to just give some of the current legal background and how these laws are impacting folks that we represent and community members, Marylanders, on the ground. For the one part, in the last couple of years, as this committee would know, that some penalties for drug possession as well as for CDS paraphernalia under Criminal Code 5619 have been changed. And currently, CDS possession for administration could carry a maximum 4-year sentence of incarceration, while actually possessing a controlled dangerous substance carries a maximum 1 year. So I think that demonstrates that the penalty sections for these bills aren't in line with some of the recent changes from this committee as well as from the legislature in general. And of course, further, you could get up to 4 years under Criminal Code 5620, but under 5619, that CDS paraphernalia has been decriminalized. Another thing that public defenders see in their casework is that paraphernalia administration, that criminal charge, is used to get around Maryland's Good Samaritan law. We've had clients that have called because a friend or family member is experiencing a health emergency, possibly an overdose and need saving. And when the officers arrive, they cannot charge the drug possession, right, because of the Good Samaritan law, but they can charge CDS paraphernalia for drug administration. So that criminal charge is being used to defeat the spirit and the purpose of the Maryland's Good Samaritan law. And for those reasons, we are here in support of this legislation, House Bill 372.
I will remember to unmute myself between now and 85 days from now. Alex Wilson. I saw Alex Wilson.
Sorry, I didn't realize I had to unmute.
Okay, go ahead.
Hello. So my name is Alex and I work for Spark Baltimore. As many others here, I work in harm reduction, a field that centers the needs of people and communities. I see firsthand how my clients, my community members, and neighbors navigate the landscape of substance use. First and foremost, as a healthcare provider, I need to make clear that this is a healthcare issue. People are trying to keep themselves and their communities safe and healthy. Despite common misconceptions about people who use drugs do care deeply about their health, and when empowered, they make choices that reflect that. In harm reduction, we know that communal solutions require communal care, and as service providers, we're tasked with helping, but we cannot do that when there's confusion. There is a lack of specific and explicit protection, as many others here have mentioned, despite the presence of syringe programs. This confusion is a barrier to care, and that confusion creates harm. Obviously, my field, harm reduction, is about the mitigation and removal of these barriers. When things are unclear, they are dangerous, and we need clarity to help keep people safe. As a harm reductionist, as a service provider, I never want to put someone in a position where the choice they have to make to keep themselves safe is between injecting safely or avoiding the harm from interacting with police. These interactions create mistrust of police, which in turn trickle down into mistrust of me and myself and organizations like the one I work for, and that's why I'm here in support.
Great, thank you very much. All right, we will go now to Dr. Joseph Adams.
Hi, thank you, Mr. Chair and members of the committee. I'm Dr. Joseph Adams, representing the Maryland DC Society of Addiction Medicine in support of HB 372. Last year, the only opponents to the bill were from the state's attorney's office, whose major point was that they needed the leverage of possible jail time to coerce people into treatment in order to help them. And that is very understandable that, that's been a philosophy for many years. And I know, family members would like any way that they can imagine by any means necessary to get their loved ones to stop using. And sometimes it works. When people are diverted into treatment, at least it works for the short term. And when it does work, it perpetuates the notion that we can stamp out drug use with the threat of jail time. But in reality, because of the nature of addiction, people are not ready to stop at any particular time because there's many other factors involved, such as, possibly ongoing mental health symptoms and social factors. So the great majority of people are seriously harmed by this approach, and many end up going to jail, which makes their chances of recovery worse. It's almost as if in my clinic, if you can imagine that I would be talking to a patient and tell them, well, you've been using drugs long enough, and next week you really have to stop, or else I'm going to call the police and you're going to have to go to jail. See how that works for you for a change. Well, that would be ridiculous. It would be malpractice. And it's just as harmful when this is done by the criminal justice system. If people buy into the whole concept of syringe service programs, which really help people in many ways, including preventing infectious disease, I think you would have to support this bill because, allowing clean needles to be available for public health purposes makes a lot of sense, and it would not make sense to make it illegal to possess those that type of paraphernalia. Thank you.
Thank you very much. All right, and now in the cavalcade from the Harm Reduction Coalition, Harriet Smith, please.
Hi there, good afternoon. My name is Harriet Smith. I work here at the Baltimore Harm Reduction Coalition. I wanted to share a little bit about our services and why we're in strong support of this bill. First, I want to explain that there's a carve out in the legislation for syringe service programs that allows our participants not to be impacted by drug paraphernalia laws. Proving that you are one of our participants is completely confusing and applied really inappropriately when left to the discretion of individual police officers. We give out little cards that somebody can write a code on the back of, or sometimes participants want to write their legal name because they don't trust that officers will trust the code, even though that is what the Maryland Department of Health has asked us to do. You lose cards. I know that my frequent sandwich buy card in my wallet is constantly tattered and falling out. This is the same quality of card. And we're expecting people, when stopped by police and they're very afraid and it's a contentious situation, to advocate for themselves using this flimsy piece of paper. Let's take it out of the equation so that they don't need to do that. One of the things that I notice, over the summer, we served about 780 unique individuals here in Baltimore City over the course of about 1,000 different encounters. One of the things that I was disappointed to have to spend a significant amount of that time discussing was how to deal with the possibility of being stopped and searched by police. And what if they were to find the syringes I'm handing you right now in your pocket? We spent so much time problem solving that likely scenario instead of talking about wound care, instead of talking about getting to HIV testing and treatment, instead of all the other life-saving necessary conversations, because this sort of carve out for SSP participants and the state's law around carrying things that could be used for taking drugs is so confusing. And so I'm asking you as a worker, as someone who's wanting to have conversations of significance, to take the confusion out of the equation and fix this in a simple way.
Thank you very much. All right, that's the second panel. Are there questions for anyone on the second panel? Seeing no one wave their hands or raise their hand on the electronically. We'll thank them very much. There are 3 further people, including one from the Harm Reduction Coalition. Samantha Kerr, is she there? Is Samantha Kerr at the Harm?
Owen O'Keefe is going to be speaking in her stead. She had to leave. Yeah.
Okay, Nancy Rosen-Cohen and then Tiffany Scott.
I'd just like to thank the committee for hearing us. As it was mentioned before, we're in the midst of a public health crisis. And as many of you know, as legislators that have helped us through the crisis, a 12% increase in overdose deaths in the first 3 quarters of 2020 versus 2019. And we must do more to embrace harm reduction strategies. I think we're all here to save people's lives. And the decriminalization of paraphernalia, as mentioned before, accomplishes several goals. One, it's supporting people who are utilizing the growing number of syringe services around the state. Number 2, it improves the cost effectiveness of public health resources. 3, it improves treatment outcomes. And 4, hopefully it will improve relationships that we have to have between law enforcement agencies and their communities. I think this committee knows, like the rest of the country knows, that discriminatory enforcement of drug possession laws over the decades has produced profound racial and ethnic disparities in the criminal justice system. Decriminalization can reduce the number of people arrested and incarcerated, reduce the collateral damage caused by criminal records, and help people feel safe enough to seek treatment when they're ready. We must focus our resources on health interventions, education, and prevention when it comes to the use of drugs and addictions. We urge a favorable report on House Bill 372, and I thank all of the legislators for their hard work in this area.
All right, we'll go now to Tiffany Scott. If Tiffany Scott is still there.
My name's Terry Bethia. I'm with Tiffany. It's myself and Tiffany. It's
My name's Terry Bethia. I'm an advocate for Impact.
Okay. Go ahead.
Okay, thank you. Like I said, my name's Terry Bethia. I live in Baltimore, Maryland, and I'm asking for the law to be amended because of the way it affected my life. Some time ago, I was on probation, and I was actually on my way moving out of the state, and was pulled over for paraphernalia, and which truly impeded my recovery. It left me stuck more or less in the state of Maryland to deal with, which was eventually was thrown out. But the just the hindrance of the whole process, it was for very little of nothing, and it was truly at the officer's discretion. It left me, like I said, it slowed my process down. I had to deal with a public defender going through the whole process of and it was thrown out. That was the thing.
All right. Thank you very much. We're going to go ahead and talk to the final person from the Harm Reduction Coalition, I believe. And is this the Owen O'Keefe from Harm Reduction? All right. We had one more person to testify, I thought, from Harm Reduction, but I don't see that.
Yeah, I think there's some technical difficulty. So
All right.
I know that Owen says me too. So thank you.
Okay, great. That's the best kind of testimony. And not really, but okay. And so for the last paneler, I see one question from Delegate Griffiths. So we'll take that question. Delegate Griffith.
Thank you, Mr. Chairman. And this question is actually for Delegate Moon, if that's okay, related to this. Wouldn't this legislation decriminalizing paraphernalia de-incentivize individuals to use facilities like the one the witnesses represent, where one of the benefits of using facilities like them is the fact that you can get this paraphernalia legally? Wouldn't this now, again, make people want to consider that less because it's no longer a concern?
It's an interesting concept. One just practical concern I would point out about that approach is that these programs are certainly not available statewide. There are many counties that have declined to take advantage of that section of law. So again, it's just going to be super patchy geographically. If it's like you're expecting folks to get out to Baltimore for a needle, a clean syringe, it's just not going to happen. And so I think that for the public health and education benefits, this sort of taking this out is a better approach. I'll point out that we did something very similar 2 years ago with test kits. So this whole paraphernalia section of the law, it has paraphernalia for drug dealers, drug manufacturers, drug packaging and shipping. And then also in there is little things for drug users, syringe, spoon. And then we had test kits in there too, drug testing supplies. And we kicked testing supplies out of there a couple years ago for the same reason, that you want to encourage people to engage in safe practices. Again, we don't want to condone the behavior, but I don't think the overdose crisis has been stopped in its tracks by the existence of these laws, certainly not. So trying to try a better approach here.
And again, a question I asked last year in the same bill about being able to use paraphernalia as probable cause. Would this prevent that?
Wow, it's an interesting question there too. I mean, again, you've got the drugs themselves. I tend to think a really tough cop who wants to do this is going to be able to find something, the residue, there's probably other, if you look at the paraphernalia law, it's actually pretty wide range, staplers, bags, Scotch tape, there's any number of things that could be interpreted into it. But it would be very nice to cleanly get the language in the 4-year penalties that refers to paraphernalia used to administer and use drugs. It's very clearly saying that this is not drug dealing and drug manufacturing stuff. So I think we've already started carving these distinctions in the paraphernalia law. And let's just finish this job and kick this stuff out of the criminal code completely and just move it firmly into health.
Well, and just one final question. I apologize for taking so much time. In the bill, and if I'm reading it wrong, please forgive me, but it mentions a scale as well. I mean, I'm unaware of a scale being used and related to drugs for anything other than distribution.
That's existing law. You have to look at where the brackets are deleting out. I think we carved out a couple words like spoon and things like that. And the rest of what you're seeing there is what's remaining.
Right, and that's why I was asking for clarification on that. Thank you.
All right. Are there further questions for this panel? Okay, Delegate Conaway, I see you.
Thank you, Mr. Chairman. To Delegate Moon, is it possible that a person might have a scale or something to weigh something by because they're on a diet or trying to control their portion intake? Is that possible?
Certainly possible.
Thank you very much.
Okay. Are there further questions for this panel? Seeing none, thank you very much. That concludes the testimony for those in favor of the bill. The one in opposition is Mr. Schellenberger. Are you still here? He is not still here. All right, he is in opposition. I believe somebody else offered written opposition in any case. All right, that concludes the testimony for House Bill 372 and the testimony for the committee for today. We will be back tomorrow with only 4 bills and 10 witnesses. So members of the committee, I would anticipate us starting right at 1:30, and it may not take very long. All right, thank you all very much for your time today, and thank you for your participation.